All right, are you all ready?
Yes, Judge.
Court is calling 2023 CR 1876, State of Texas versus Evette Martinez. Can I have parties announced for the record for the state?
Daniel, for the state of Texas.
Defense? I'm sorry, for the defense?
Glenn Payne.
And are you Evette Martinez?
Yes.
All right, she entered a plea of true to violation of 14M. And there are some other violations in the report that the state waived, but the court had concern about. And it has to do with testing and what is happening with that. Is that correct?
Yes, Judge.
And you have a witness here?
Yes, Judge. The state reached out to Lifesaver. They were able to provide someone who appeared in court that was on video.
All right, any objection to this witness appearing by Zoom?
No, Judge.
All right, Mr. Rendon, can you raise your right hand?
Yes.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Octavio Rendon.
Any questions?
The court was the one that wanted to have answers just on
Yes.
what's going on.
All right, so here's the problem. The problem is I keep receiving these reports. There are skip tests. She's saying that there's an issue with the machine and it's not with her. So we're trying to figure out what's going on with that. Because according to the report I received, she has 77 skip tests from December 13th, 2023 to June 10th, 2024. And it states that those skip tests have been discussed, but defense and I believe Ms. Martinez are saying it's an issue with the machine. It's not her.
And
Yes.
are you waiting for Mr. Rendon?
Oh, sure. Or if you have something to add, you're more than
Well,
welcome to add it.
Judge, I just wanted to draw the court's attention. The 77 tests over many months.
Mhm.
As you can see on that MTR, there would be 12 tests here or 10 tests there.
Mhm.
I also want to draw the court's attention. I mean, that she tests 3 times a day.
Mhm.
And all the other tests, they were not positive.
Mhm.
It was just that these were tests. Now, I guess does the court just want to inquire to Mr. Rendon if
Well, I
a
wanna-
machine can be defective?
No, I'm trying to understand, why do we have these skip tests? I think when y'all were here last time, people said they had an explanation for the skip tests. Am I remembering incorrectly?
Yes, Judge. I mean, what we said was that the machine, and Mr. Rendon, I guess you can see this. Is this your machine?
Yes, sir.
And I, just so you can see it. Judge, I spoke to my client, and this is a new machine that she received just after the 4th of September. And when she was talking to a troubleshooter, basically, they said that the power
Well,
cord.
I mean, he's here to answer some questions. So if you have some questions, what she's saying, what somebody else said, that's all hearsay. If you have questions for him about power cords or whatever, then you all can ask him.
Well, Judge, I believe what my client, I mean, is the court inquiring? Or,
Yeah,
I mean,
I'm trying to figure out what is going on. She is on probation for intoxication assault. I know that y'all only pled true to 14M, and 14M is she failed to register or attend the DWI intervention program. All right, so the reason why I'm inquiring about this, because she failed to attend that. She needed to attend that. She didn't. Whatever y'all agreement have, I need answers about this. Otherwise, for her failing to do that, maybe she needs to go to prison. I don't know. Maybe she needs something else. I don't know. So, Mr. Rendon, question him. What is up with this device? Why is there's an issue with this device?
Mr. Rendon, I guess let me inquire to what your specifics are in your job. I didn't call you as a witness, so I'm not familiar with you, sir. Can you
Yes,
please
sir.
tell me?
So my title is Business Development Manager. I recently acquired that title. Beforehand, I'm a field operations manager for the company since 2017. And I've actually started with Lifesaver since 2011. So I've been working here. I know the device. I know the data. I've been doing this for a while.
So are you familiar with these type of devices and
Yes, sir.
troubleshooting these devices?
Yes, sir.
Okay, have you had to troubleshoot these devices before?
Yeah, been occasionally. So the device relies on um, uh, like a cellular network, and a lot of times our defendants or clients can go outside of cellular coverage. When this happens, we are bound to help the customer to repair the device so we can get the data back, which we do occasionally. And if the test is missed and the client's actively missing the test, the device will register a refusal and it will register a GPS location as to where the device is. So just given, is there a particular date that we're questioning as far as missed test or just all of the missed tests in general?
Well, I guess what I'm trying to get at is this is a machine and runs on a battery, correct?
Correct?
And it can be plugged in and batteries ever go bad in these machines, like our cell phones and everything else that batteries go bad?
Bad would be a term that I don't think exhausted. That may be you use your cell phone all the time. I may have to recharge my phone a couple of times a day, but as bad, I don't think that's a correct term for it.
Have you ever had to replace a machine for a battery or a bad charger or anything simple like we have to do with all the devices in our life?
I've had to replace devices for a broken port when the customer forces the USB into the side of the device and it breaks that port.
Okay, so thank you, I'm sorry, I didn't mean to interrupt you. Now, are you familiar with Miss Evette Martinez's case at all?
I have her information in front of me.
Okay,
After-
is this the device that she has now? Can you tell whether it has been replaced?
Correct.
It was replaced?
It was replaced on the 3rd of September. As
What was the reason?
reason why we may do it if the client is inquiring that they want a new device, then we're bounded to give them a replacement at that point. That does not mean that the device is bad. That does not mean that there's something wrong with the unit. It just means that at that time, if the client inquired or if the court inquired, we are able to replace the device if necessary.
Has that device been run a diagnostic on it, the old device?
No. So once we receive a device that is shipped back to a manufacturer in Cincinnati, Ohio, but the data from the device is real time. So all we can see is what happened prior to the device being exchanged and what happened after the device was exchanged.
So you have all the data there present?
Correct.
So can you send that to the court so that we can review it?
Yes, sir. Am I gonna be sending that to Mr. Escobar?
Yes, you can spin it to Escobar.
So Judge, with him sending the information over, I'd like to have time to review it,
Sure.
to have to reset to review the case before court passes judgment.
Okay. All right, Ms. Ferguson. Can you bring this back on September 16th?
And Judge, for the record, I have the DW education program slip that my client should have submitted to the court.
All right, if you'll give it to probation.
We'll do that.
All right, we'll see you back on that date.
You say the 16th, Judge?
Yes.
Oh, it's Monday. Okay, that's easy.
All right, thank you. Thank you, Mr. Rendon.
We're gonna have
Yes,
Mr.
ma'am.
Mr. Rendon, can you appear by Zoom on the 16th?
Correct.
All right, thank you. It'll be the
Thank you.
same Zoom link.
No
Judge,
problem.
you set this for a specific time since we have a witness coming in at Zoom. Do you want to do it in the afternoon?
No, we can do it at 9. If everybody's here at 9 and he's ready to go at 9, we'll pick it up.
Okay.
Thank you.
Thank you.
You're welcome. Thank you so much. Court is calling 2024 CR 1943, State of Texas versus Isaac Chavez. Can I have parties announced for the record for the state? Defense?
Doug Campbell for the defense, ready.
And are you Isaac Chavez? Are you the same Isaac Chavez who was placed on deferred adjudication in 2024 CR 1943 for the offense of possession of a controlled substance penalty group 2, 4 to 200 grams on April 15, 2024 for a period of 4 years? Is that you? State?
On or about the 22nd day of June 2024 in Bear County, Texas, the defendant Isaac Chavez committed the offense of evading arrest or detention of the vehicle in violation of condition number 1. Your Honor, do you want me to read all of these and then allow Mr. Chavez to give his plea
All
in
right.
total or each one individually?
All right. Let me ask Mr. Chavez, with regards to the alleged violations of conditions, there's a violation of condition number 1, 2, 8A, 14C, 14Z, and number 34. Are you pleading true or not true to those allegations?
Not true.
To all of the allegations within the motion?
Yes, Your Honor.
All right. Then the defendant is pleading true to violations 1, 2, 8A, 14C, 14Z, and 34. All right, State, do you have witnesses?
Yes, Your
All right, State, you can call your first witness.
Honor. He calls Angeline Nicholas.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Angeline Nicholas.
All right, State.
Ms. Nicholas, how are you currently employed?
With Bear County Adult Probation.
And what do you do with Bear County Adult Probation?
Supervise cases,
I'm sorry, you're gonna have to keep your voice up so the court reporter can hear.
sorry. I supervise cases, make sure that they're following the conditions.
There is a microphone in
Yeah.
front of you. If you would put it up, you can see the microphone so the reporter can hear you.
Sorry.
Do you supervise a person named Isaac Chavez?
I do.
Is that Isaac Chavez with Bear SID 1158016?
What was the, so?
1158016?
Yes,
And do you see that Isaac Chavez in the court today?
I do. Yes, right, yes.
Could you point him out so the report by an article of clothing?
Gray dress shirt,
Thank you. When did Mr. Chavez begin his supervision?
April 15th, 2024.
Now, on June 22nd of 2024, did Mr. Chavez make an admission to you regarding his use of alcohol?
On June 24th of 2024, that's when I met with him, but he did admit that it happened on June 22nd, yes.
And when you say it happened, you mean that he consumed alcohol?
Yes.
Now, Mr. Chavez had a number of conditions of his supervision. Among them was to complete one AA meeting per day for 60 days.
Yes.
According to your supervision of Mr. Chavez, how many AA meetings per day did he complete?
It was more so one per week,
And how many in total?
8.
Did Mr. Chavez provide proof of employment or SSI within 30 days of his release?
No,
Has he provided any proof of employment?
no,
Did he register for or attend a drug offender education program?
no verification has been provided.
Now, did you give him a referral for a drug offender education program?
Yes,
Did he provide any documentation that he registered for it or attended?
no,
Did Mr. Chavez at any point provide proof of residence?
no,
Passage, Your Honor.
Defense?
Ms. Nicholas, were you aware that Chavez was living at 8603 Cape Valley?
yes, he let me know that he was living there.
What more proof would you need than his word if he was living with a parent or somebody else?
You said what more than his word? Usually, if they're living with parents, the parents need to write a letter stating that he's living there with a proof of one of their bills.
Did you tell him that?
I don't recall.
Did you ever go out there to see if there was any proof that he was living there?
No.
With respect to the once per day for 60-day Alcoholics Anonymous classes, are you sure he was aware of that?
Yes,
How are you sure he's aware of that?
his conditions were read to him in court, actually, by the CLO.
And at the time he went on probation, he was 19 years old.
I believe so.
Have you ever, in your dealings with Mr. Chavez, had the thought that perhaps he might be a little bit immature?
I mean, yes.
And as a result, do you think that maybe he didn't fully comprehend what was being told to him?
I wouldn't say didn't fully comprehend what was being told. It's just maybe more so of kind of just taking his time with it. I mean, I'm sure he fully comprehended what was needing to be done.
As a now 20-year-old, he probably has a little bit more sense of urgency on needing to get these done, especially since we're here in court, right?
Yes.
Were you aware that he was working at Willie's?
Yes.
And you say he never gave you proof. What steps did you take to try to verify that he's working at Willie's?
We normally ask for proof of employment.
Did you discuss that with him?
Discussed it, yes. I didn't document it though, if I'm being honest.
Did you tell him, hey, when you really need proof?
I didn't make it an urgency thing.
Okay.
To be honest with you.
And then with respect to his drug offender class, having dealt with 20-year-olds before, and certainly somebody who lives with a parent at 20, do you think maybe he was waiting for you to do something? No, you think he was fully aware that he needed to
Yeah.
take that extra step and set up the class himself?
Yes, because we provide the verification, let them know like, hey, go through the list, figure out where you're gonna go and register. That responsibility is totally on him.
Okay. And you say that Isaac had admitted to using alcohol as a 20-year-old to you.
Mhm.
Do you think he benefits from perhaps some additional classes on the dangers of alcohol and drugs?
Yes,
Do you think, now there was a report written for the court, right?
yes,
Did you write that report?
most of it.
Most of it? Do you agree with the recommendation for this particular person?
No, not necessarily. For the younger probationers, I tend to be a little bit more compassionate, give chances, hope that they'll learn better. So I wouldn't say no.
Do you think Isaac should have another chance at trying to be successful on his community supervision?
Yes.
Why do you believe that?
Like I said, I just try to give a little bit more compassion to the younger ones because they're a little more respectfully hard-headed, and it takes them a little more tries to get it right.
That's especially true with male defendants or
I would say
clients, I
all of
guess.
the younger ones.
Yeah.
I wouldn't specifically say no, all of the younger ones.
Okay. Do you think he can be successful now that he knows how serious this is?
Yes,
Why do you believe that?
because this is his second MTR, I believe. But I think at this point, we know to be serious.
All right, it's his first MTR.
First, in this case.
In this case, yes, sorry.
Yes.
Thank you. I'll pass the witness.
Any other questions?
Yes, officer, do you have a copy of the court summary in your hand?
Yes.
Can you please turn to page 3?
Yes.
Underneath the field marked justification, there is a signature line that says community supervision officer. Is your signature above that line?
Yes.
Would you please read the recommendation that is above that signature line?
It says revoke, no offenses and non-compliance.
And below that is justification. Would you please read the justification?
The probationer bonded out of, the probationer bonded out on new offenses. And he has not reported to probation since bonding out. The probationer has not shown a valid effort to comply.
As part of your duties, is it your responsibility to proactively investigate the information that a probationer is required to produce to you?
Yes.
Yes. So for instance, if a probationer is required to produce proof of employment, are you obligated to go out to his potential employer and get proof yourself, or is he responsible for providing it to you?
Oh, he's responsible for providing it. We don't go out to the employers. I could always ask the field team to do that. But they're responsible for providing verification.
And for proof of residence, it's the probationer's responsibility to provide that proof to you, correct?
Yes.
And for proof of attendance at Alcoholics Anonymous meetings, it's the probationer's responsibility to provide that proof to you, right?
Correct.
Same for registration and attendance at a drug offender education program. It's their responsibility to provide proof, not yours, right?
Correct.
So on or about the 24th day of June 2024, did Isaac Chavez provide proof of residence as required under condition 8A?
No.
On or about the 24th day of June 2024, did Isaac Chavez provide verification of Alcoholics Anonymous meetings as directed by the court, as required by condition number 14C?
No, those are, no.
On or about the 24th day of June 2024, did Isaac Chavez provide proof of registration for or attendance of a drug offender education program as required by condition number 14Z?
No.
On or about the 24th day of June 2024, did Isaac Chavez show proof of employment or SSI within 30 days of release as required by condition number 34?
No.
Is Mr. Chavez prohibited from consuming alcohol under the terms of his supervision?
Yes.
Is that under condition number 2?
Yes.
Did Isaac Chavez admit to consuming alcoholic beverages to you?
Yes.
Did he admit that he consumed alcohol on or about the 22nd day of June 2024?
Yes.
Thank you.
Any further questions?
Oh, Your Honor.
All right, thank you. State, call your next witness.
Calls Officer Ramos.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
I recently got married, so technically my name is Brianna Gonzalez.
I
So-
object.
Yeah, so.
All right.
I know my name still says, I just got married on the 9th, so.
All right, congratulations.
Thank you.
All right, state.
How are you currently employed,
I'm employed as a police officer with the Leon Valley Police Department
and how long have you been employed with the Leon Valley Police Department?
since March of this year.
And what is your current assignment?
I'm a patrol officer for the city of Leon Valley.
On June 22nd, 2024, what was your assignment?
Just regular patrol duties as a patrol officer.
And are you assigned to night or day?
At that time, I was assigned to days.
On June 22nd, 2024, at approximately 7 a.m., were you dispatched to a particular incident?
I was dispatched to what I believe was a welfare check, what it came up as on the CAD system, to go check on, or I'm sorry, that was your question, yes.
Yes. And the location to which you were dispatched, that was in Bear County?
Yes,
And when you arrived at the dispatch location, what's your?
I observed a car on Huebner Road, just on the street. The light was green, but the car was parked, or it seemed to be parked. I don't know if the driver's foot was on the brake or if it was in park, but they were stalled in the middle of the road as if they were parked.
And can you briefly describe this vehicle?
The vehicle was a Lexus, four-door vehicle.
Do you remember what color it was?
I don't, I know it's on my report. I put it down. Was I supposed to have that with me? Sorry.
That's okay. So upon seeing this vehicle, what did you do?
Well, because of the notes in the system, I activated my red and blue lights and I got behind the vehicle to initiate a traffic stop.
Did you get out of the vehicle, out of your vehicle?
I did not get out of my vehicle at that time, no.
And what reaction, if any, did the operator of that Lexus have to you activating your patrol vehicle's emergency overhead lights?
Initially, the operator of that vehicle did nothing. When my partner got out of the car, along with another officer that also pulled up to that traffic stop, they both got out of the car. I was about to get out of the car, but then the vehicle suddenly drove forward and it stopped in the middle of the intersection of Huebner and Bandera Road.
What happened next?
What happened after that is we all got back in our vehicles. We both got closer to the vehicle. Then we tried to get out again. I stayed in my car at that point. I didn't get out. And again, the two officers, the one in my vehicle and the other officer, got out to try to make contact with that person again, and that vehicle fled and evaded. So at that point, I told dispatch that I had a vehicle evading arrest.
And at that point, what did you do?
At that point, dispatch asked if I was in pursuit. I said no. So I was still behind the stopping point for that road. So I abided traffic laws and I waited for that light to turn green. That way I could turn.
Now, a short while later, did another officer communicate to you that they had detained the vehicle?
It wasn't communicated, it was observed. Because I could see it. It wasn't very far at all.
Okay. Was this vehicle the same vehicle that you earlier observed and that sped away from you?
Yes.
What did you do upon relocating?
Upon relocating to that vehicle?
Yes.
Oh, well, again, my lights were already off. So all I did was, as soon as the light turned green, I turned left onto Bandera Road and I got next to because my other officer, he had initiated a second traffic stop. He initiated his red and blue lights again on the same vehicle, and I stopped with that officer to try to initiate contact again.
And did you initiate contact with the operator of the vehicle?
Yes, eventually, because again, the other officer made that second traffic stop technically, and then we took him into custody at that point.
Did you identify the operator of that vehicle?
Yes,
How did you identify?
we asked him for his name eventually.
And what did he say?
He said his name was Isaac Chavez.
Did he provide a state issued ID of any kind?
I don't recall.
Did he give you a date of birth?
He had to have, yes.
Let's not operate under assumptions.
Yes, he did.
Okay. Do you see the operator of that vehicle in court today?
Yes, I do.
Would you please point him out to the court by an article of clothing?
He's in black pants and a gray dress shirt.
Now, after you detained him and began to interact with him, what observations, if any, did you make?
He appeared to be intoxicated.
Did you observe the odor of alcohol emitting from his breath?
Yes,
Did he admit to consuming alcohol?
yes.
How much alcohol did he claim that he had consumed?
Initially, he claimed that he only had one drink, but upon further questioning, I asked him, okay, what did you drink? And he said he drank Modelo and Smirnoff, so it didn't make any sense.
Did you make any other observations about his physical appearance?
Yes,
What observations were those?
he appeared to have urinated on himself.
Is that the only other observation that you made about his physical appearance?
Other than his glossy red eyes, he appeared to have soiled himself. And the odor of alcohol on his breath. No, that was about it.
Did you ask Mr. Chavez to submit to standard of sobriety tests?
Yes.
And what was his response?
His response was he wanted to speak to a supervisor first.
Did you call the supervisor?
I did.
And did that supervisor appear?
Yes.
Did that supervisor speak with Mr. Chavez?
Yes.
And after speaking with that supervisor, did Mr. Chavez submit to standard of sobriety tests?
No, he refused.
At that point, what did you do?
We formally told him he was under arrest, for evading and DWI. And, we read him his rights, and, from there, we transported him back to our police department.
Officer, would you agree with me that all things in life are a matter of perspective?
Not all things.
How can you be sure that Mr. Chavez saw the lights when you were behind him?
How can I be sure?
Mhm.
I mean, he's not legally blind as far as I know, so they're really hard to miss, so I can't be sure, but any reasonable person, even intoxicated, could have seen those lights.
And he pulled over immediately when the other car stopped him, right?
Well, he was actually already stopped at the red light, so he didn't technically pull over, but he didn't make any further attempts to flee at that point.
Right, and I guess that's my point. If he was just, based on what you're saying, he was asleep in the intersection, right? If he's just waking up, we're not sure he even knew you were there, right?
His eyes were open when I saw him.
Did he recognize you? Can you say that he recognized you?
I could say that he could have recognized a police officer in a police car with their lights on, yes.
Should have, but there's a chance that he didn't, right?
I'm sure, yes, there's a chance.
And during your interactions with Isaac, was he cooperative for the most part?
For the most part, yes.
And he courteous
For the most part, yes.
and compliant? Once he was stopped, right?
Completely compliant, but the other questions.
And you don't know what his blood alcohol level was because you don't have the labs back yet, do you?
Well, he didn't consent to blood, actually. He initially did and then didn't, but he had a blood draw, so no, I don't know what those results are.
So you can't say with certainty that he was intoxicated.
No, I can't.
Thank you, I'll pass.
When you spoke with Mr. Chavez, did he slur his words?
Yes.
Did he stutter?
Stuttering, I don't recall, but slurring, yes.
No further questions.
Thank you.
Thank you.
State, any other witnesses?
That's all, Your Honor.
I'll call Isaac Chavez.
All right, Isaac Chavez. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Isaac Chavez.
All right, defense.
Thank you. Isaac, we've already identified you as the same guy who's on deferred adjudication for possession case, right?
Yes, sir.
Can you tell the court what was going on June 22nd of this year?
The day I was
Yeah.
stopped. Oh yes, I was at a friend's house. It was just supposed to be a normal hangout, but he ended up inviting other friends. I do admit that I did have alcohol, but I was peer pressured. I was trying not to at first, but just to fit in, I fed in.
Now, just to be clear, you're 20 years old, right?
19 at the time.
19, okay. And despite all of that, you understand that it's illegal for you to drink alcohol when you're under 21 in the state of Texas, right?
Yes, sir.
And despite all of that, you told your probation officer that you were drinking, right?
Yes, sir.
And did you see the police officer who was behind you in the intersection over in Leon Valley?
Not the person.
If you did, what would have happened?
I would have put over immediately.
And that you didn't try to run off when the second officer stopped you, right?
No.
I'm gonna ask you a question. I told you I needed you to think about this. Why do you think the court should continue you on deferred adjudication?
Truthfully, it's just I do acknowledge that I made a mistake. I acknowledge that I was irresponsible. But truthfully, for the past 3 years, I've been completely sober. I've been working honest jobs, helping with my family, my grandfather. Honestly, I was on the straight road. I was doing everything right. I don't believe.
let's focus on some of the other violations that they've alleged. You've already told the judge that you admitted to drinking, that you did drink. Why didn't you ever provide any proof of where you were living to your probation officer?
I didn't necessarily know how. I told her where I lived and I had my ID. I didn't really know what more proof was needed.
And the 8603 Cape Valley address is on your ID?
Yes,
And they looked at that every time you went in, right?
yes,
So you felt like you complied there.
yes.
There's another allegation that you failed to go to Alcoholics Anonymous every day for 60 days. Did you understand that that was one of the requirements of your community supervision?
I did.
Why didn't you go every day?
I did actually go every day. I have the proof in my cell phone. I have the email sent to my probation officer. I have about 56 of them of every day that I went.
So do you take issue with the fact that she only testified that you went once a week?
I do, yes.
What did you learn, if anything, at the Alcoholics Anonymous meetings?
So let me just stop you. Where is the proof of this?
Judge, I don't have it. It's in his cell phone. I can't.
Oh,
I'm not
where's the
gonna-
cell phone? Did anybody look through his cell phone?
I did not, because I asked him to print them.
All right, you all want to step back and state, you can look through his cell phone and see if there's actually documentation that he did it. And I'm sure if he did it and it's proof there, maybe the state will waive the,
Well, it's just one, Judge. I got other ones I still got to address.
I know, but step back, let's see if he actually did that. Johnny Tejeda, all right, we're here for,
A motion to revoke, Your Honor.
all right. Is this going to be a plea true or is it going to be contested?
It's a true plea of truth.
Okay,
We have a recommendation for the court's consideration.
all right. Court is calling 2022 CR 7806, State of Texas versus Johnny Tejeda. Can I have parties announced for the record for the state?
Daniel S. Clark, the state of Texas.
Defense?
Alex Shar for Johnny Tejeda.
Are you Johnny Tejeda?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Johnny R. Tejeda who was placed on community supervision in 2022 CR 7806 for the offense of failure to stop and render aid death on February 9, 2023 for a term of 10 years? Is that you?
Yes, ma'am.
Right, state?
Violated condition number 1, on or about the 15th day of July, 2023. In Dare County, Texas, defendant Johnny R. Tejeda committed the offense of drugs while intoxicated in violation.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, state waives all the violations.
All right, any objection to the waivers?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you to 10 years in prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement was for the pleas for DWI.
No, it has not been completed yet.
Sorry about that.
Sorry.
The defendant has entered and sat with Martin following after Saturday.
That is our agreement, Judge. I do have some witnesses to give you some context.
Yes.
And so at this time, if I may, Your Honor, I would like
Yes.
to call Daniel Garcia.
Can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, I do.
All right, you can lower your hand. State your name for the record.
Daniel Garcia.
All right, defense?
Thank you, Your Honor. Mr. Garcia, what do you do for a living?
I'm medically retired from the Navy,
Okay, how long were you in the Navy?
13 years.
All right, and but when did you get out of the Navy?
I got out in 2013, medical retired.
Okay, all right. Now, do you know Johnny Tejeda?
Okay.
And you recognize him as the client that's in the orange jumpsuit,
Yes.
correct? All right. Tell the judge how you met Mr. Tejeda.
We met each other through, cars, rented old cars.
Mhm.
And then, had a house come up for rent. So I had asked him, if he knew anybody that wanted to rent a house, which he said that he would. Cause he was on a hard time, so I went to the house to him. And, that's kind of how we met.
And how long ago was that?
That was about a year and a half ago, maybe a year and 3/4 now.
Okay. Did you know him prior to doing that? Like, how long have you known Johnny?
For about 3 years total now.
Okay. Are you just his landlord, or is there a closer relationship?
He's like a brother to me. We're supposed to start a business. For doing custom paint
Mhm.
and,
Okay. When you met him, what was your judgment of his
so when I first moved
character?
in, he was really sad and angry. Over the time, I started talking to him and found out more about him. And then we started hanging out more. Usually he comes to the house and then he'd go back.
Okay.
And, he's just totally different from a year and a half ago to now.
Okay. Now, are you aware that he was placed on probation in February of 2023 for a failure to stop and render aid that caused a death?
No, at that time I didn't know any of that.
Okay. But when you did meet him, how did that happen?
Well, like I said, when I asked him that I have a house up for rent, he said he moved in and I didn't know anything about that. But usually I'm a good judge of character and I let him move in. I'm not gonna let him move into a house
Okay.
somebody destroyed.
Okay, and how was he as a tenant?
Good. I mean, if he was a bad person, I wouldn't have him in there. I would have kicked him out a long time ago.
Okay, so what is it about Mr. Tejeda that helped you come to a conclusion about his character? That he's a good guy.
It's kind of hard to explain because I mean I met a lot of people in the military and he's a good person. It's kind of hard to explain, but
Well, can you try to explain it? Like, and give the judge some
he's always been there
examples?
for me because I'm a single parent with 3 kids, and when my significant other left about a year ago, he was there for me, and we kind of helped each other out through the hard times that we're going through.
What do you mean help each other out?
We'll just talk, basically. I don't drink. I'm taking care of 3 kids on my own, so he'd come over and we just hang out. He doesn't really talk to anyone, but a couple of people.
Okay, and the people that he was hanging around before you two started getting into a closer relationship, how would you characterize those people?
There's no way to say dirtbags, I guess. I don't know how to say it.
Okay,
People that I wouldn't hang out with.
okay, that's fine. I mean, dirtbags, that's.
So I got my friend, my other friends that I hang out with, they're one used to work in the movie industry. Another guy is works for the AC, so they all got stuff going for themselves. We're building cars. So when he started hanging out with me and he told me the guys that he used to hang out with, I don't hang out with people like that, so I don't know how else to say it.
Okay, well, all right, so I mean, did you take on the role of like a close friend or father
No,
figure?
more like a brother.
Okay.
He started coming hanging out with us, and we're a real tight group. It's only like 3 or 4 of us that hang out together.
Okay.
And if he was any different, he would have kicked us out. Would have kicked them out.
Okay, how would you describe his work ethic?
He's always busy. I know he has a lot of cars coming in,
Okay.
and we still have some more cars that need to be finished.
What kind of does he do body and paint? Does he do
Body and
engine?
paint, custom paint. Not so much engine, but pretty much body and paint.
All right. Please continue.
Okay. Okay, so, all right, so when you told the judge that you noticed a big change in him, can you give us some specifics as to like how he was before and how he is, how he is now?
Before, he was always always in a bad mood, always depressed, I guess. And now he's always there. He's always just a real good guy. I don't know what's
Okay,
reliable.
okay. Um, so like 3 years ago, when you met him, you noticed he had a lot of anger issues and depression.
Yeah, yes.
Okay, and have you seen any improvement in him?
Yes, I've seen a huge improvement from then to now.
Okay. The anger that you saw,
It's not there no more.
okay, and what about the depression? You're not an expert on that, but
Right.
just from your
No,
contact with him.
we're supposed to start a business, so I mean, if his mind wasn't in the right place, he wouldn't be the right person.
Okay, all right, so, okay, so this business that you were talking about, who would be funding the business? Would that be you?
Yes, I'll be funding
Okay.
this.
All right, and would it be fair to say you trusted Johnny enough that
Yes,
you were gonna open a business with him as your main employee?
Yes, I trust him wholeheartedly.
Okay, all right. Now, you understand that in July of last year, Mr. Tejeda was involved in a driving while intoxicated as a second offense.
Well, I don't know about the first offense. The second offense, I want to pick them up from Bouncy.
Okay, so yeah, let's talk about that. All right, so how did you find out that Johnny had was in the hospital?
One of our friends told us that he got into an accident. So I went to go look for him at the jail, and then I got a call from his dad saying that he was at Bouncy. So I said, I'm retired, so I still went in and got him out of there on the Bouncy.
Okay, and could you tell he was injured?
Yeah, he was pretty banged up. As far as I know, it was his ribs and wrist, and that's as far as I know.
Okay. All right. In the event that the judge does follow the agreement and continues him on probation, and she is in an inpatient substance abuse alcohol rehabilitation center, which it could be for 6 or more months. Would you still be willing to go into business and continue mentoring Mr. Tejeda and treating him like a brother?
Yeah, still.
All right. Is there anything I haven't asked you that you wanted to tell the judge about Johnny?
No, I mean, he's a real good person. You know, I mean, if he wasn't, I would not try to be investing money into a business between me and him. There's no way.
Okay. Now, one thing I forgot to ask you about is after you picked him up from the hospital, were you upset at him?
Yes. So when I picked him up, I kind of talked some smack to him, told a couple of friends, and they kind of talked to him like, "What are you doing?" You know, I can't say what.
Okay. Well, I mean, did you specifically tell him anything about the type of people that you hang around with?
Yes, I specifically told him that.
Right, so tell the
That
judge.
I don't bring people that are messing around into the people that I hang out with, because we have a lot going for us. Trying to do a lot of things here in San Antonio. I moved here from California back in 2013 on opening a business. And the issue is that I haven't met too many people here that I could trust with money wise.
Mhm.
So when I met him, it just clicked. So I started bringing him around, and everybody agreed to what he's about.
All right, pass witness.
All right, any questions? All right, thank you. All right, so I can tell y'all, this is what's going to happen in this case. Either he's going to prison or he's going into inpatient treatment to safety. Those are your two choices.
Okay,
I'm not doing SATIF. He doesn't need SATIF. He needs something that is longer, he needs something longer, and that's safety. So he can do safety or he can do prison. Those are the choices.
As far as, can I just maybe give some, my 2 cents as to
Sure.
those choices? I respect the court's decision and appreciate that. As far as the substance abuse felony punishment facility, in talking to clients who have been there and how that program is designed, yes, it is long. Yes, it is in the prison system. But it's run not like an individual rehab or a group rehab where everyone is accountable for themselves, but it's run as, for lack of a better analogy, like the scene in the movie Full Metal Jacket, where one person makes a mistake and everybody else gets punished. And in my opinion, about recovery, I don't think that's the best way to impress upon someone, to change their, to get a psychic change in their mentality and to adopt, a spiritual full change in their attitude if they're being held responsible for what other people do. When the program is all about being responsible for yourself and only trying to control yourself, because that's all you can control. I understand the length of the program. I've had cases where people were finished with the program and then they go to a halfway house and they're living in San Antonio and they get sent to a halfway house in El Paso and there's no support group there. The substance abuse treatment facility, I know some of the people that work there. I know some of the people that work in recovery within the Bexar County system. They're good people. They teach the program and they do it well. And it can be anywhere from 4 to 6 months long, followed by aftercare. So that's a substantial amount of time. And so I'd ask the court to reconsider sending Mr. Tejeda to SATIF, reconsider sending him to Safe P instead of to the substance abuse treatment facility.
Okay. All right. He's going to Safe P or he's going to prison. And then as far as aftercare is concerned, he can speak to probation when they get to that point. And if you find a halfway house here in San Antonio for him to be in, preferably lifetime recovery, then he can go to lifetime recovery, and lifetime recovery can place him in a sober support facility.
You want to go, Mr. Tejeda, do you want to go into the substance abuse felony punishment facility? Or you just want to go to prison?
I'll go to the substance abuse.
Safe P.
Yeah.
All right. Court will deny alternate main conditions to include Safe P and probation. Can we do Safe P followed by lifetime recovery? All right. So once he's completed with Safe P in custody and they're getting ready to send him to a halfway house, just let the court know. All right. Thank you.
Thank you, Your Honor.
All right. Is there anything else?
I didn't know if you needed to sign a certificate of appeal or anything like
No,
that.
I do not. All right. Thank you. Thank you.
Judge.
Exactly which ones. Some of them were on verification, the cases I was
All
told
right.
the
If you
court
want
has sites for, so.
All right, if you want a chance to read that, you can, but from what I reviewed, it appears that I can give restitution in this case.
That's fine. I mean, I'll take exception to your ruling, Your Honor. I think.
Well, no, I mean, do you have some case law
Well, I have-
that addresses 42.037?
I have case law that, yeah, I can get you the sites. I have them here on my
Okay.
computer.
All right,
Yeah,
sure.
Yeah, I can write them down and give you the sites.
Okay,
Yeah.
awesome.
Okay.
All right, just step back. Miguel Naranjo Perez, court is calling 2024 CR 3071, 2024 CR 3072, State versus Miguel Perez-Naranjo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Susan Darza for the defense, A&D RCA.
And are you Mr. Perez-Naranjo?
Yes.
Did you understand in the cause number ending in 7-1, you're charged with violation of motor fuel tax requirements as a second-degree felony? And in the cause number ending in 7-2, you're charged with fraudulent possession or use of credit or debit card, 10 to 50 items as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. Did you understand that the court were to grant your application for deferred adjudication?
Excuse me, I'm sorry.
If for any, no problem, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 20 years in prison and up to a $10,000 fine in each cause number.
Yes.
Are you a U.S. citizen?
No. No.
Are you a resident?
Yes. Yes.
Counsel, did you inform your client of the consequences of entering a plea in this cause number as it relates to his immigration status?
Yes, Your Honor. In fact, the case was negotiated in a way that will, he has a way to still fix his papers after the first.
Okay, I didn't hear what you said.
That yes, we reviewed it and we pled it in a way that was recommended by the immigration attorney.
All right. And Mr. Naranjo, were you informed by the immigration attorney that you could be deported and not allowed to re-enter the United States by entering into plea bargain agreements in each of these cause numbers?
Yes.
Were you explained by your immigration attorney that you could potentially be denied naturalization?
Yes.
Did you understand the consequences as it relates to your immigration status in entering into plea bargain agreements in this cause number?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, your punishment is to be assessed at a $1,500 fine. Cases will run concurrently. State will take in consideration 2024 CR 3070. There's to be restitution to several individuals as well as Walmart. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
That is clear, yes.
State, is that the plea?
Yes, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 8 years. There'll be a TAP evaluation and 150 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in each cause number, how do you plea? Guilty, not guilty, or no contest?
Guilty.
Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. All right, the court is going to order a TAP evaluation, and at that time, the court will make a decision on his application.
Thank you.
Probation, if we do a TAP evaluation, I'm sorry, is he out of custody or in custody? All right, he's out of custody.
Judge, can I have 2 weeks?
Yes. Ms. Ferguson, can you recall this in I'll give you 3 weeks. Can you recall this in 3 weeks, please? All right, we'll be back on October 3rd. I'll make a decision on your application once I've received the TAP evaluation. Yes. Did you want a PSI as well or just the TAP evaluation?
Well, if the PSI will help you.
Oh, I just need a TAP evaluation.
Okay. Oh, that's fine.
All right, so it's just the TAP evaluation. All right, thank you. All right, Doug Campbell, you ready on your client?
Again, yes, we got an opportunity to talk about your 2 options.
Mhm.
And I think my client would like to take the local ISF.
Okay.
if that's an option.
All right, we're back on the record. And cause number 2024 CR 1943, State Waive 14C without objection. Court is finding violations of condition number 2, the consumption of alcohol true. 14C, state waived it. 34, the court will find true. 14Z, the court will find true. 8A, the court will find true. Number 1, evading arrest or detention, the court will find true. Number 1, driving while intoxicated, the court will find not true. All right, probation, my understanding in this case, you're not recommending revocation? Although, I'm sorry, they are recommending revocation. All right. All right, this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include probation. Since I'm denying the motion, do you recommend local ISF or state ISF? Because it appears we have alcohol issues as well.
Judge, so I did speak to defense counsel and I talked about ISF that is just going to address cognitive. However, if you do send him to state ISF, that you could order him to the substance abuse cognitive track. Obviously, there's differences in the wait time in custody for both facilities. So that is something I think defense was going to address.
Well,
Somehow,
sometimes that's punishment.
fair enough.
All right, so it's going to be state ISF. And there's to be partial GPS for employment only upon release. And I'll ask that GPS fees be waived. All right, all other conditions will remain. All right, anything else?
No, Judge.
All right, we can go off the record. You better start doing better. Otherwise, you're going to prison. And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone. You're young, you know? And I'm telling you truth. You're going to be sold for a pack of cigarettes or some extra dessert. That's what happens at the prison sometime. And this persona that you're giving me now, that's not going to help you at the prison. And maybe people will start fighting with you. Maybe sometimes somebody at the prison be like, I don't feel like fighting with him today. They may say, yeah, I feel like fighting with him today. And that's what you're going to be doing. And the fact that you're young and you're doing dumb stuff is not going to help you at the prison. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
All right, the court is calling 2024 CR 0092366W, State versus Thomas Henson. Can I have parties announced for the record for the state? Defense?
Attorney Alvarez for Mr. Henson already, Your Honor.
All right. And does he also have a motion to revoke as well?
Yes, Judge. I don't know how the court wants to handle that.
All right. Well, we're going to do the motion to revoke first. The court is also calling 2022 CR 5859. Are you Mr. Thomas Nathaniel Henson?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Thomas Nathaniel Henson who was placed on deferred adjudication in 2022 CR 5859 for the offense of aggravated assault with a deadly weapon on September 15, 2022 for a term of 4 years? Is that you? Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
I
All
think
right.
that was partially, part of the agreement, Your Honor. We were also going to be asking, obviously, if you would consider, continuing him and keeping him on the deferred after further testimony.
All right. Now that I've taken his plea of true on that, let's proceed with the new case. Counsel, have you received all of the discovery?
I have, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you understand you're charged with evading arrest detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
According to the plea, the state is recommending community supervision. They'll be silent on your application for deferred adjudication. It's to run concurrent with 2022 CR 5859. They're taking in consideration 2024 PF 06107, 2024 PF 06357. Did you understand that to be the plea?
Yes, sir.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, and no contact with Susie Castaneda. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, do y'all have something that shows him identified as D1? It has him as S1. And based upon what I've read in the police report, it appears that he is D1, but I deal with the 4 corners of the
I
document.
understand it.
So the only persons who are identified, they have someone D1 and C1, and they have D1 as the driver. So does anyone have any identifiers of who D1 is?
I can pull it up there.
All right, thank you.
I have looking off.
Okay, thank you. And then this is going to have to be set for PSI if there's sufficient evidence to find him guilty.
Yes, Your Honor.
And Norma, what will be a PSI date for this? I'm just waiting for them to give me more information. All right, then the stipulations will be supplemented with the document given to the court, which has the identifiers. After reviewing that document, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. This will be set for sentencing on October 28, 2024. I'm going to order PSI and TAP, and at that time, I'll let you know whether or not I will follow your plea bargain agreement. All right, is there any other questions? All right, and then we'll take up the motion to revoke on that date as well. All right.
Thank you, Your Honor.
You're
May I be
welcome.
excused?
Yes,
You have a good day.
thank you. All right, and then Jay Juarez. All right, we're back on the record in 2024 CR 1043 State versus Jay Juarez. And Mr. Basil, the court had considered your argument. The court reviewed Article 42.037 with regards to restitution, and based upon that article of the courts, it's in the court's opinion that the court can still order restitution in this case. And I'll let you place on the record whatever you would like to place on the record as it relates to that. And
Yes,
then
Your
we'll
Honor.
speak towards the restitution.
It's the defendant's position, Your Honor, that since this court granted the deferred adjudication on March 7th, 2024, and at that time in the court's judgment, there was restitution was listed as 0. And on the conditions of probation, there was no amount of restitution listed. That by rule of law, that order became final after 30 days and became a final order, just like if the defendant wanted to appeal, he didn't want deferred adjudication, he would have to have filed that within 30 days. On June 12th, the supplemental request was submitted for set the case for restitution hearing, which is more than 30 days after that, and is the defense argument, Your Honor, that the court at that time does not have the authority to go back and change the judgment. And I've submitted some cases. I wrote them down. My computer's battery's about dead here, so I'll have to read them off the paperwork Your Honor gave you.
Yes, no problem.
Cases that I've researched, and while there's not directly, so court knows they're not directly on issue because they're mostly talking about probation, and I understand the statute that you're talking about mentions probation. Most of the time, there is some places in there, it does talk about deferred adjudication on there. It's Cox v. State, 445 Southwest Second, 200. That's the Texas Criminal Court of Appeals, 1969. Bailey v. State, 160 Southwest Third, 11. Also Texas Court of Criminal Appeals, 2004. Ex parte Cavazos, 2003 Southwest Second, Third, 333. Texas Criminal Appeals, 2006. And ex parte Roberts, which is 409 Southwest Second, Southwest Third, 758. Texas Appeal San Antonio, 2013.
All right, thank you.
Those are the cases that were provided on the notes to the court that I'm relying on, other than just the general, also under again, under notice provisions under due process clause, United States Constitution, the Fifth and the 14th Amendment, and the Texas Constitution, Article 1, Section 19, which requires that he be given due process before any life, liberty, or property is taken from him. And it's our argument that since that order was final, the court does not have the jurisdiction to do that.
All right, and the court will note for the record that on March 7th, 2024, as a part of the plea bargain agreement, the court ordered that restitution was to be determined to Kenyana, Keyyana Warner. And according to the plea bargain agreement, the plea bargain agreement stated that restitution was to be payable to Keyyana Warner, the victim in cause number 708710. That was a part of the plea bargain agreement that was agreed to by Mr. Juarez on that day. And that is a part of the contract that he signed. With regards to the judgment stating that no restitution, it states $0 restitution. The court is finding that that was in error. It should have been that restitution was to be determined. And this case has been reset more than once for both parties to come together to see if there is an agreement on restitution. The first restitution hearing was scheduled for June 25th, 2024. Then it's reset for July 18th, 2024 for the state to obtain proof that the complainant did not use insurance. And that was at the request of the defense because the complainant had a deductible. Then it was recalled for August 1st, but defense attorney was ill. And then it was recalled on August 1st because the defendant was ill on July 18th. And then on August 1st, we were to have a restitution hearing and a witness was allowed to appear by Zoom. And now we're here on September 12th. So have you all come? The court has received documentation of a preliminary estimate for restitution. And they put that total at $6,399.22.
That's correct, Your Honor. I've received that. I've reviewed that with my client, and my client is desiring to have a hearing and evidence presented on that amount. I've discussed that with him in detail last time and further detail today in the courtroom.
All right, state, you'll need to have witnesses here then for this being the amount of restitution.
When you're on.
All right, so what we're gonna do, and this is gonna be the last setting that I'm giving everybody for restitution.
Just so the court knows, Your Honor, I will be out starting tomorrow through next Wednesday. I'm having a medical procedure
No.
done tomorrow, and I will be back. So I'm just.
All right, do you want to do it, is October 21st good for you or no?
No, that's fine. I'll be back before then. I just want to let the court know if you want to do it next week, I'll be out.
Okay, no problem.
And Your Honor, I should be able to secure.
All right, Norma, this case is going to be recalled October 21st, and this will be the last setting for restitution.
Your Honor,
Yes.
will Ms. Warner be allowed to testify via Zoom? There is no objection from defense counsel.
I have no objection to that.
All right, they'll be allowed, she'll be allowed to testify by Zoom.
But, Your Honor.
All right, thank you. All right, you all are excused.
Thank you.
Thank you. All right, is there any other cases we have on the docket? Or are we done? Yay. Okay.